Why are these papers closed? Why are pages blacked out? Why do sealed filings hide names we see in other records? The public has watched court dockets and redactions. The image of a courthouse file folder with tape across it became a symbol of missing answers. For years, sealed court documents tied to Jeffrey Epstein kept many facts from view. This secrecy shaped public anger. It bound reporters to the margins of what courts allowed. Sealed files are not rare in law. Jeffrey Epstein was a financier. Born on January 20th, 1953, in Brooklyn, New York. He worked as a teacher in the early 1970s. He later moved into finance and advised wealthy clients. Over time, he accumulated homes in Manhattan, Palm Beach, Little St. James. Reports show he used private jets and had wide social access to the rich and powerful. Epstein's social circle included business figures, politicians, celebrities. In 2005, the Palm Beach Police Department began investigating allegations against Epstein after a parent reported that a minor was sexually exploited. The Florida investigation led to interviews and evidence collection. Federal prosecutors in 2006 opened an inquiry, but the process that led to a 2008 resolution stayed central to later disputes. On June 30, 2008, Epstein pleaded guilty in Florida State Court to procurement of a person under age 18 for prostitution, to solicitation of a prostitute. He entered a plea deal that produced an 18-month county jail sentence, with work release and a broader non-prosecution agreement that shielded potential co-conspirators from federal charges. The deal was controversial from the start. Victims said it was too lenient. Critics said it was too lenient. On July 6, 2019, federal prosecutors in the Southern District of New York arrested Jeffrey Epstein on charges of sex trafficking minors, New York, Florida. The indictment alleged a scheme spanning years. Epstein paid minors. Epstein transported minors for sexual activity. The arrest followed renewed scrutiny. Investigative reporting victim statements publicly surfaced in courts. Epstein pleaded not guilty. Denied bail, held in the Metropolitan Correctional Center in New York. The case set up a high-profile federal prosecution that many hoped would bring fuller answers. On August 10, 2019. What the Epstein files contain: civil complaints, deposition transcripts, flight logs, financial records, witness interviews, settlement agreements. Civil suits filed by victims often contained detailed allegations and named people who allegedly interacted with Epstein. These filings sometimes included exhibits such as flight manifests, email records, as found in civil filings in New York, and federal court dockets summarized by major outlets and publicly filed documents. Some documents were sealed to protect names of alleged victims and minors. Other parts were sealed under agreements between parties, including settlement terms that required confidentiality. Court clerks held files under seal. Some exhibits were filed under restricted access. As portions were unsealed, they revealed emails, calendars, witness statements. Released materials showed flight logs that listed numerous passengers over years. Why papers were sealed and how they were unsealed. Courts sealed Epstein-related documents for several stated reasons: protecting minors, preserving privacy of victims, safeguarding ongoing investigations, honoring settlement confidentiality when legally required. Defense and prosecution sometimes agreed on redactions. Judges often issued sealing orders, citing federal or state privacy rules and protective orders in civil cases. These legal bases appear in many sealing orders found in case dockets, sample sealing orders in court dockets available via PACER and public reporting. The push to unseal came from victims, media organizations, some lawyers. Courts received motions under the First Amendment and the common law right of access to judicial records. Some magistrate judges ordered partial releases. Appellate courts, prosecutors reviewed and sometimes opposed releases. Key names, places, and public records. Court papers and released files name multiple locations tied to Epstein: his Manhattan mansion at 9 East 71st Street, his Palm Beach home, his private island, Little St. James, and his private jets, often called the Lolita Express in media accounts based on flight logs. These places appear repeatedly in depositions and victim statements that are now public in part. Names in documents include alleged victims who filed suits and gave sworn statements. They also include employees, pilots, and social acquaintances who appeared in flight logs or emails. Unanswered questions and a call for transparency. Many core questions remain. Who else knowingly aided the alleged crimes? Which names on flight logs reflect wrongdoing? Which names reflect innocent travel? Did all relevant records surface in the releases so far? Courts still seek documents that might show fuller patterns. Journalists still seek documents that might show fuller patterns. Victims still seek documents that might show fuller patterns. Judges often limit access to protect privacy or ongoing investigations, yet the volume and scope of the Epstein materials made secrecy feel different. Victims pressed for openness, reporters pressed for release, courts weighed competing claims in long, technical hearings. The tug-of-war reached a wider audience after new arrests and court motions in 2019 and afterward. Some records waited in federal courthouses. Some records waited in state courthouses. Some were in civil cases filed by alleged victims. Some were part of criminal case files. For a long time, the files were called simply the Epstein files in public conversation. The name stuck because the papers offered a map, partial and folded, a map of people, a map of places, a map of claims. The map drew scrutiny the day new seals were challenged in court. The curiosity hook is simple. Sealed records can hide answers. They can also protect vulnerable people. The legal balance between secrecy and public right to know set the stage for battles in filings, appeals, media requests. Those moves shaped how and when the public could read the records. They also shaped what the public still does not know today. Released materials showed flight logs that listed numerous passengers over years. They showed photos and evidence that placed individuals at Epstein residences. They showed statements in which alleged victims described alleged incidents and timelines. The released parts also included sworn statements later used as evidence in motions and appeals. At the same time, many pages remained redacted or withheld. Judges balanced privacy interests against public right to know. The released files were pieces of a larger puzzle. When read together, they offered patterns. When read alone, they left gaps that demanded further legal motion or new investigative reporting to fill. The files, are fragments that point to more questions than answers sometimes. Courts and media have carefully noted when a name is simply listed on a log versus when a filing makes an explicit allegation of wrongdoing. Public sources with released documents include court dockets available via PACER, state court records, and reporting by major outlets who obtained records through litigation and public filings, such as the New York Times, the Miami Herald, and ProPublica. Legal filings often include quotes such as "the defendant transported minor females," or statements by victims in sworn declarations. For example, civil filings quoted in news reports include direct victim claims now public in court records. Readers should note that names appearing in flight logs or depositions are not proof of guilt. Court papers contain allegations, sworn statements, and documentary evidence of varying weight. The law requires proof beyond allegations to establish criminal liability. Public records, however, remain a key route to learning what courts have already documented and what is still under seal. So the records point to leads, not necessarily conclusions. The path ahead is procedural. The path ahead is legal, not immediate or guaranteed. Quiet. The files wait. The questions remain public. The legal process will decide which pages open next. Epstein's death ended the criminal case against him and left many questions about the full scope of his activities unanswered. Those questions redirected attention to civil suits and sealed court files. With the principal defendant dead, many sought public records to learn more. Journalists, victims, courts turned to the sealed documents to try to fill gaps that the halted federal prosecution could no longer fill. Major unsealing moments occurred in 2019-2020. For example, in 2020, a judge ordered the release of a trove of documents related to Epstein's non-prosecution deal and related civil suits while still permitting redactions for victims' names. Each release was piecemeal, often limited by protective orders and appeals. The result is a mixed public record. Some documents are now public and have been used in reporting and civil litigation. Others remain sealed or partially redacted. The legal record shows how courts balance competing rights. The public and journalists continue to file motions and appeals seeking further releases when law allows. So, yeah, it's an ongoing judicial tug-of-war over access and privacy. The record to date shows facts. The record to date shows names. The record to date shows places. The record also shows limits. The search for answers continues. Subscribe and turn on the notification button for more videos.